esteemed persons in the dais, the various office bearers of the ABA Organizing Committee, Ms. Pratibha Jain, dear friends in the audience, I've been asked to address you on future of legal education, glocalization of legal profession. So before I begin to reimagine legal education in India, let me try and address this August gathering in portmanteau form. Portmanteau, I discovered after this conference, in the context of this conference, is, of course, a blending of at least two words in keeping with your glocalization mega theme of this conference. So my guess estimate, that is guess plus estimate, is that this metaverse, that is meta and universe, attended by this impressive collection of brainiacs, that is brain and maniacs, under the auspices of ABA, is destined with its impeccable planning and diverse sub-themes to be a Bollywood, Bombay plus Hollywood, hit in the legal education ecosystem. This is my first detailed encounter with portmanteau forms of titles for seminars. Friends, reimagination of legal education in the Indian, but also in the global context, can be fruitful, infectious, delectable, and delicious. Legal education and law schools are the bedrock, the foundation whose quality, workmanship, and solidity determines the beauty, the longevity, and the functional utility of the superstructure of law. President Radhakrishnan's lament 50 plus years ago, he said, our colleges of law do not hold a place of high esteem either at home or abroad, nor has law become an area of profound scholarship and enlightened research. Unfortunately, though lesser, but unfortunately even today, has substantial resonance. A small number of dynamic and outstanding law schools still remain islands of excellence amidst a sea of institutionalized mediocrity. A few general points. A lawyer has to be a balance wheel, a harmonizer, a reconciler, more than simply a skilled legal mechanic. He must also be a legal architect, an engineer, a builder, indeed an inventor. That's a lot of things to expect from a lawyer, but good law schools are supposed to do all that. Our contributions must therefore focus not only on GNP, but also on GNM, gross national mind. The character of law schools determines the character of the bar and the bench, the two wheels of the chariot of justice. We must avoid time wastage in reinventing this wheel and focus only on tying up the vast existing corpus of rich data on legal education available already into a simple, uniform national legal education plan and concentrate on its implementation in a consistent, continuous, and coherent manner. India's failure has always been the gap between promise and implementation. Democratization of law schools and of legal education is vital. While there is need to create more islands of excellence and eminence, like the institutions of eminence, for example, there is far greater need to uplift the average standard of the struggling, anonymous 1,500-odd law schools. We have to spread, therefore, distributive equity over inclusive legal education and minimize what has always been the bane of India, the many Indias within one syndrome. Substantively, our legal curricula must be made multidisciplinary, creative, and flexible. Global best practices adapted to local needs and nuances should be our guiding pole star in this glocalization endeavor. Antithetically, our curricula are actually, in most cases, rigid, stereotyped, and pedantic. There is an urgent need to integrate topics like reforms in justice delivery system. Very few courses in very few places still in 2023 have that. into alternate dispute resolution, practitioners' workshops, legal writing, clinical legal education, and so on and so forth. Sadly, teaching methods have also hardly evolved after the case study methods of the 1970s. A typical Indian law student may have about 9 to 10 optional subjects to choose from, whereas at a leading US law school, he'll be able to choose from amongst 200 to 300 offerings. Of course, as a slight aside, it is heartening to see more and more law schools across India building into their components reciprocal foreign interactions with foreign established universities. Whether in a semester, whether in an exchange program, whether in a visit, different models are on. There is absolutely no doubt, and each one of us who has had the privilege of studying abroad in any form for any duration, and I very fondly recollect my Cambridge years in this regard, there is absolutely no doubt that an approach to problem solving, which you learn with this global methodology, holds very valid and gives you a new insight in your local problem solving. So, how you approach a problem, how you solve domestic problems, in a sense, the foundations are frequently laid in the degree of globalization of your legal education when you were a student. Secondly, friends, there is a very serious problem of law teachers, or rather the lack of them. A vexed problem of numbers, of quality, of diversity, and of depth. Former Chief Justice Anand called law teachers, quote, largely marginalized, demoralized, unrecognized, and unrewarded, unquote. Law teaching can attract brilliant young minds only by shortening the substantial and unbridgeable financial gap between the leaders of the bar and the teachers. Reciprocally, those under special remunerative schemes have to be bound by valid legal instruments, bonds with appropriate legalese, to teach for a minimum duration without straying into greener pastures. A pilot program must create an alternative remunerative scheme, not hidebound by the present shackles of bureaucracy, and bureaucracy includes everything from UGC downwards, with more public-private partnerships, greater autonomy, and special financial terms. In all of this, global paradigms waiting to be adopted stare us in the face. Thirdly, friends, our law libraries are too few and woefully stocked. Latest technological tools of research must link each law school with the best sources of knowledge globally. A library cess levied only on senior advocates across the country must be operationalized for law libraries for maximum ground impact, and in particular for ground impact in urban India and rural India. Here again, of course, urban, you have another portmanteau example. Fourthly, some students, especially with contacts, unfortunately in India, have the luxury of plenty, while several of their more talented but less resourceful colleagues go a-begging. There is no objective evaluation system by the chamber head. What you need is an organized, computerized national plan for placement, allocation, internship, and training. As seniors in chambers, we find that there's a jungle raj out there. There's chaos, and I'm sure a lot of you applicants find the same. Fifthly, a national scheme must ensure that senior practitioners with expertise in particular areas compulsorily take a minimum number of classes in lesser endowed law schools, which should be part of the student's evaluation, namely that particular course or class. The legal education sector, the bar, the bench, the corporate legal sector, and the law firms, unfortunately in India, continue to function in silos of isolated splendor. The exact opposite, close, continuous, coordinated alignment in legal education is the need of the hour. Again, local and global best practices are available but remain largely unadopted. Our national law schools shone because of broadly three important innovations. academic autonomy by making it a standalone university. That's true in most cases, not all. Entrance through a strictly merit-based admission system based on a written test. And thirdly, an integrated professional 5-year law program with curricular innovation. Why we don't do this, these three basic building blocks of excellence, even partially in several other law schools in India, whether 3-year ones or 5-year ones, to me it remains an enduring mystery. There is, friends, a 2009, that's 13 odd years or 14 odd years old, resolution that all law schools should establish a legal aid center to provide inexpensive and efficient advice to needy sections of society, with final year students imbibing training at such legal clinics and benefiting from client interaction. Unfortunately, this also has been observed mostly in the breach. And you can't be misled by institutions of eminence or institutions of excellence which remain islands. Ninthly, the impact of stratification of colleges, of law colleges, has to be remedied if you want to reimagine legal education in this country. Central universities set up by Parliament have their law faculty as the university's law school. The problem arises at state-level universities, which become affiliating bodies for private law colleges. There is here an institutionalized mediocrity and dilution of academic standards, in particular in the affiliated colleges category. Many do not have adequate and qualified faculty or law libraries, e-resources, and even no regular conduct of classes and examinations. One statistic tells it all. 3 Western UP state universities alone, 3 state universities in Western Europe, Meerut, Agra and Kanpur, have affiliated 214 law colleges. And they offer almost 25,000 seats in LLB alone. I'm giving you a microcosm of one part of India, one part of a state. How can you expect high quality standards or an appropriate academic ecosystem? Linked to this, of course, is the imperative need to axe, to render extinct, to eliminate, to exclude. What? To exclude many, many, many existing law colleges. Madras High Court, a judicial body, as far back as 6 years ago in 2017, said that 85% of law colleges need to be closed. This is not my figure, I was astonished to read it. The irony, of course, is most interesting. After the Madras High Court said that 85% should be closed in 2017, the number has jumped from 800 in 2000 to 1500 in 2019. We are somewhere around 15 to 1700 now. Not 15,000, sorry, 1500 to 1700. Of these, in my opinion, and as I said, as Palkiwala used to say, words to lead to some reform have to be an assault on the mind. So don't mind my bluntness. But if some reform has to happen, there must be some assault on the brain of those who have the policy powers. Closure of at least 500 of these 1,500, if not 750, dubious and substandard profit shops is urgent and imperative. These are mechanically churning out 1 lakh lawyers, that's 100,000 lawyers. The speed and scale in which we are producing law graduates is poorly matched with the quality of education, training, capacity building, opportunities that are available for law graduates. And here, a fundamental reimagination of this ecosystem is needed. At last count, unfortunately, no Indian law school, barring 2, found place in the top 300 law schools in the QS rankings. Global winds of ruthless competition must animate this area. More than Darwin, only the fully fit should survive in this ruthless global competition, or global competition, as per your title. All NLUs combined impart legal education to only 2,500 students per year. Now, these are the islands of excellence, which we are proud of. But look at the numbers they touch, the lives they touch. All the NLUs combined give 2,500 students per year, which is about 2% of the total LLB students admitted annually. 98% in terms of quality, availability, capacity building, opportunity is the big question mark. Our starry-eyed view of 5-year courses, which are very good, very desirable, and have become the fashionable buzzword for the last 2 decades, must not omit to strengthen the 3-year program. On par with the JD or the Juris Doctor program of American and Canadian law schools, so popular, so good, I would say, the Indian LLB 3-year program must be made more rigorous and full-time. And those who don't have it, even the NLUs, some of them should consider starting it, because there is nothing wrong or evil in a student wanting a 3-year broad-based education followed by a 3-year law program. There is a unique aspect of legal education in USA, which in my young years I've been very impressed with. Deep and pervasive engagement between law firms, corporations, non-governmental organizations, legal aid centers, think tanks, government agencies, intergovernmental organizations. I just mentioned silos in splendid isolation, ivory towers in splendid isolation. The exact opposite is happening here in India. This interaction, let alone collaboration with these 6 or 7 sectors I have just mentioned, is superficial, if at all existent. Last, friends, the elephant in the room must be addressed. And it's a big elephant and a powerful element. Only foolish persons like me might fear to tread where angels might fear to tread. The elephant in the room is the Bar Council. The Bar Council has too many functions. It's powerful not only because it's statutory, but it has just far too many functions. Law reform, disciplining lawyers, setting standards for legal education, and the vicissitudes of electoral politics, sometimes too purple and too vicious, willy-nilly, will necessarily compromise some degree of the discharge of these multifarious and diverse functions. You can see that I am using words carefully and cautiously, and also words of studied moderation at least. But I am still trying to speak the truth. So friends, I have earlier said, stuck out my neck, and I have no hesitation sticking out my neck again today. Either an empowered, broad-based, separate committee of academicians, chief justices, eminent lawyers should be set up, or an independent and autonomous National Council for Legal Education and Research, even if generally created by BCI, but independent and autonomous from the BCI, is necessary to bring the needed objectivity and purity in the legal education arena. Friends, as I end, all I can do is to remind you of some stirring words about capturing in legal education the promise and the premise reflected by thinkers like H.G. Wells, who many, many moons ago said, human history, more than anything else, is a race between education and catastrophe. Aristotle, even earlier, put it nicely when he said education is an ornament in propriety and a refuge in adversity. What India needs is a new electric fire to stir up fresh vigor in our legal education veins. Roadblocks and pessimisms should only remind us of Tagore's Akla Chalo, and more importantly of Gandhi's description of 5 stages of reform, something which is very well known but frequently forgotten. Gandhi said all such reform initiatives go through these 5 stages. First, indifference. Second, ridicule. Third, abuse. Fourth, repression. And fifth, respect. So don't be deterred. So long as we move in the right direction, success is bound to be ours. Thank you very much.
Thank you, Dr. Abhishek, Manu, Singhvi, I would call your approach both diagnostic and pathological towards legal education. So based on what you have submitted, I've drawn 3 propositions which I would like to make it a point of departure towards the panel. Number 1, legal profession is a natural extension of the law school. Number 2, we need a reimagination using global probably as a critical vantage point. And third, we need this reimagination to be channelized in a way that our law schools do not become Olympiads of mediocrity, if I may borrow this, this critical expression by Professor Shiv Vishwanath, one of my distinguished colleagues. The manner in which this panel is composed, there's a challenging heterogeneity to it. It has a distinguished academic who's also an educational leader. It has 2 leaders of the profession who are also passionate about academics. We have people with extra academic, co-academic, extended academic interests in the panel, ex-academics in the panel. So let me make that a pretext to burst into an academic discourse. That's not what we have been hearing the whole day. I love this term, especially the portmanteau glocal. It's a combination of global and the local. So there was a time when people living in the local began to sense an unknown, something they have absolutely been unfamiliar with hitherto. And they understood that it's a global imagination looming large before them. That became an existential reality for the people living in the local, and then we gave this portmanteau glocal. But of course, the global gave us cosmopolitan identities. It gave us global imaginations. At the same time, global made the local extremely relevant, because global is a holism which is nothing but an integration of the many local. So one of the positive impact of globalization is that it actually made the local extremely relevant for global reimagination. Now, that being the background, and since we have only 30 minutes left, I would like to submit 4 questions. More than questions, they are rather propositions which I would like to submit before this distinguished panel, and I would request the panel actually to reflect upon those 4 questions. Number 1, when global became the reality, when laws were rewritten by the state as part of a positive harmonization of universal minimum standards to become law of a globalizing, liberalizing economy, what transformations happened at the professional level in the early stages of globalization? For example, did the global change the human, social, and legal relations? Or did social become the commercial? Or did global change the nature of disputes and the ways of dispute settlement? I'm talking about those early days when we began to feel this strangeness of mind. Second, legal education, which was otherwise intensely domestic, developed 2 approaches with the onset of globalization. 2 buzzwords began to emerge in the law schools. One is comparative, another is transnational. Now, transnational is knowledge about the conflict of laws in a meta space to which laws have transcended from the domestic. And comparative is essential knowledge of other locals. How did legal curricula change to situate the transnational and the comparative in its process? Third, governing the global was easier said than done, as it was about connecting the 2 worlds hitherto unknown, an absolutely disconnected world of global and the local. Because of this, new actors began to appear on the global landscape with expert knowledge of the global, the local, and also the interplay of the global and the local. Now, these actors include NGOs, think tanks, consultancies, policy institutes, which developed expert knowledge on all aspects of this strange phenomenon, globalization. Both legal education and legal profession heavily relied on the services of these actors, which include taking studies and advices on local administration, rural governance, property laws, tax systems, domestic violence, and poverty. I request the panel to illustrate and explain, if possible, the essentiality of these global actors in the global landscape. And my 4th and the final point, another interesting phenomenon of globalization is laying down of regulatory structures in what was previously the domestic space of the state. These regulations are nothing but ways and means of domesticating the surging elements of global within the local. There are also regulatory agencies. We do have representatives of regulatory agencies in this panel which make these regulations and take regulatory decisions. How are they situated in the professional legal landscape and their role perceived in the legal education? I'll start with Dr. Surat Singh, and we'll, of course, take everybody's reflections, and then as every quasi-judicial body, every panel is free to frame its own procedures. So we'll frame it as we move forward. Over to you, Dr. Singh.
See, coming from a simple, uneducated farmer's family, I have the privilege of studying at Delhi University, where a person like Dr. Singhvi also was there for a while, and Honorable Chief Justice Dhananjay Chandrachud was my classmate, same class. I was the president of the class even then. Then Europe, Oxford, America, Harvard Law School, where I have the privilege of studying with who later became President of the United States, Barack Obama. Now, what education really means, whether it's global or local. As John Dewey used to say, education means empowering human beings to achieve those goals which are worthwhile to achieve. Lord Macaulay in 1835 said, in famous Education Minute, wonderful question, solution may be wrong, but wonderful question he asked, what is best worth knowing? What is best worth knowing? What we should learn, what should know. Now, when I was studying at Harvard Law School, many people will say, you are from India, American law is different. When you go back, so why do you study? If you come for medicine, engineering, we can understand. But law, American law different, Indian law different. Let me tell you what they teach you at Harvard Law School. They don't teach American law. They teach how to think effectively, which is needed everywhere. They teach how to communicate effectively, which is needed everywhere. They teach how to connect with the people. That is needed everywhere. They teach how to think about issues not only for present but for future. That is needed everywhere. How to think globally, not just individually. That is needed everywhere. So there are certain qualities which are needed today, which will be needed tomorrow and hence. So those 4-5 qualities law school should teach. One is ability to think critically and appreciatively. I use the word respectful questioning. I learned at Delhi University, Supreme Court decisions and all that, but only respect, not critically examining them. Example, at Delhi University they will teach you what is Maneka Gandhi's case. We will say Maneka Gandhi's case say so. And if you reproduce in examination, teacher would be happy. I was gold medalist. At Harvard Law School, they will teach in Sullivan versus New York Times. Do you agree with Justice Brennan or do you agree with other Justice White? So you have to apply your own mind instead of just rote memorization. And that as a Supreme Court lawyer, I do every day. Respectful questioning is the most important quality which is needed in the world. 2 words are there, respect, because you are not the first comer. Universe was there before you, so you should have respect for all the wisdom of the past. But old is not always gold. There's a lot of garbage which comes from the past. So ability to critically analyze what is worth saving, that is questioning. So respectful questioning, 2 elements. Second is ability to master a lot of material. These days in this age of Google, a lot of information are there, a lot of noise are there. How to make sense? So mastering the things, coming to the very crux of the things, we read about 2,000, 3,000, 5,000 pages a day. And next day, we have to summarize in 2 minutes. Ability to master a lot of the material and then ability to communicate it. What is communication? Ghalib has put it very well. Apna kaha, gar aap hi samjhe to kya samjhe. Apna kaha, gar aap hi समझे तो क्या समझे, मजा कहने का तब है एक कहे और दूसरा समझे. मजा कहने का तब है एक कहे और दूसरा समझे. We do that as a lawyer every day. We communicate to the judges. So that communication, then ability to connect. Then of course another quality, whether it's India, Europe or America, everywhere, cash is very important. Making money. So ability to make big money is the most important quality. It's a global quality, it's a local quality. Thank you very much.
Thank you, Dr. Singh. I particularly like this expression of awe which you have used here, because in law schools, one of the major problem is that we admire personalities out of awe, not really out of understanding. Definitely only skeptical questioning can develop that essential understanding. Now let me invite Dr. Poonam Saxena to give her reflections.
Thank you so much, Sreejith. When Professor Rajkumar invited me to speak about this particular topic, and I was thinking, I'm a family law person, what can I say about this law in the age of glocalization? And then I just looked at my course curriculum and I said, oh, there is so much that we can share. We learn from the West, and then we also lay down laws that are affected in the Western domain. So it's a kind of a learning on both the sides, at the same time respecting the laws, our local laws, and then making a space for each of us. I'll be very, very specific. My domain is family law. There are general discourses. My friend Dr. Surat Singh has made, Honorable Mr. Abhishek, Manu Singhvi has given a general discourse. And I also know, Sreejith, that I have very little time. So I'll just take out on 2 points how family law has been influenced by the Western thinking and the globalization component, and what are the local law, what are the domestic laws in the domain of domestic relations, which do take into account our, the content, local content, and irrespective of whichever nationality the other party may be, they have to subscribe to, they have to adhere to and abide by the local laws. One, of course, is the global nature of the social equations that we have. That will be a very positive impact of it, but I'll summarize in this, that now more and more new kinds of relationships have come up. And there is an increased acceptability of these kinds of relationships, which were unheard of in one sense previously. For example, live-in relationship. Not only they have been decriminalized, but then there is also a statutory recognition of it by relationship in the nature of marriage, even though Velusamy says that this is what is meant by relationship in the nature of marriage, or Indra Sarma says one. But traditionally, in a patriarchal society, this was not the case, where young men and women who are eligible to get married can express their choice not to get married, but live in a particular relationship that was, just imagine, when I was a student, at that point of time, typically frowned off. You'll be branded, called names if you enter into these kinds of relationship. But yes, globalization has done this. Not only this, there is so much sensitivity now towards sexual minorities and also transgender. We also have an act that is Transgender Protection of Rights Act. Now, all this has happened because not that these were not the issues with us at the time when we were students, but they were not spoken about. Now we are talking about these issues. I will just speak about that. And yesterday also, Honorable Chief Justice of India's judge, there was a mention of it about the right of an unwed mother to terminate her pregnancy. Now are the times where illegitimacy is not an stigma. People are going to the court and then enforcing their right to know who the father is. So times have changed, and globalization has a lot to do with it. Now, coming to the local laws that have a local component, I'll say, when we were a student, we were taught the famous Jagat Singh versus Teja Singh case, and that, the course curriculum and the subject was labeled as marriage and divorce and conflict of laws. The terminology has changed. Now the terminology is interface between the domestic laws and the global laws and the jurisdiction of the court. And the usage of a different terminology says it all. Now there is an interface, no conflict. And I'll take one illustration. I have the watch before me. Just 5 simple illustrations in brief as to how in the domain of domestic relations, this glocalization becomes very important. One, with the recognition of foreign decrees. If two parties marry in India, go abroad, one of them seek divorce, by invoking the jurisdiction, that foreign decree will not be recognized unless and until two things are there. One, that particular ground on which that foreign decree has been obtained is the ground for divorce in the domestic laws. That is an ample illustration of glocalization. And second, that this particular party against whom the divorce decree has been obtained was given an ample chance to represent her case. That is one. In the area of guardianship, now welfare of the child is a basic concept. Even though the child may be an American citizen, even though the parents might have become American citizens, but if the parent brings the child here, being Indian, and then the courts have the jurisdiction to try that particular case in accordance with the welfare of a child concept. That is again an illustration of glocalization. You take a look to very, very important, the CARA guidelines with respect to adoption. If the couple who is desirous of taking a child in adoption comes to India, the complete guidelines, the age requirement, eligibility requirement, home study report, everything has to be decided in accordance with the local laws, and they have to abide by it. Assisted Reproductive Technologies Act, that is called popularly surrogacy. The commissioning parents, even if they want to take the help of a surrogate mother here, the complete, not only the guidelines, the act is there of 2021, and then they have to abide by the conditions of eligibility requirement and other things that are specified in it. And then the old age, that will be my last example, the old age rule with respect to succession laws. Anybody can buy immovable property in India subject to certain restrictions and the compliance with certain formalities. But if a person who may be a foreigner leaves immovable property and, dies, then the law of the land that governs succession to the property. Some illustration with respect to glocalization that is in the area of domestic relationship. Thank you, Sreejith.
Thank you, Professor Saxena. Thank you very much. That's a very interesting perspective about the presence of new actors in the landscape of family law, with new identities, new personalities, and new rights and claims. But I believe that family law has always been a domain of local imaginations. Comparative always existed there. The transnational always existed in family law. But I have a follow-up question, but probably we could come to that a little later. It's that the new interpellation of the local into the global has created a kind of interculturalism in family law. How the discipline has prepared itself for responding to the challenges of this interculturalism, but maybe we could come to that a little later. I'll give an opportunity for every speaker. So now I'll move on to Mr. Lukose. Well, I'm sure that you have engaged with a lot of studies concerning the locals, law schools, professionals, and other agencies might have approached you seeking information, particularly on the local, because you belong to that community which possess expert knowledge about the local. How would you like to respond to that? You may respond to this specific question or largely to the points I've submitted.
Thank you, Dr. Sreejith. So our work at Vahura over a decade has been in the professional domain. So across law firms, corporate legal departments, litigation, law schools, and now legal technology. And I'm going to touch on two principles to illustrate the points. The first is the client principle. And if we look back at when liberalization happened and there's the flow of global capital into India, what happened is that for legal practitioners, the nature of the client changed. The client became the international law firm and then the international general counsel. And with that change of client, the nature of legal practice as well changed in terms of the standards that were expected, the form of drafting, writing, communication. And what's come out of that is the birth and the tremendous success of the modern Indian law firm. I see a lot of law students here, and which is why the law firms which today are in India are very much at international standards. That has had a knock-on effect in terms of legal education as well. Dr. Singhvi mentioned islands of excellence. In our own research, what we found is if you look at the corporate legal space, the talent for corporate legal, and this is law firms, this is commercial litigation and corporate legal departments comes from about 70 law schools today. A large majority of these 70 law schools were set up after the year 2000. So we're seeing a knock-on effect on the change of the client to legal education and the profession. Another interesting statistic from our research, and we track movement of lawyers both in India as well as from India outside. There's been, in the last 3 years, there's been a significant increase in lawyers from India going abroad to international law firms, which is not that surprising in itself. The key statistic for us is that 60% of these professionals have experience only in India and have qualified only in India. They are not dual qualified lawyers, and that is very much a new trend. Extending the client principle to the corporate legal domain, especially since the year 2010, we've seen an increase in sophistication in the corporate legal department and the rise of the significance of the general counsel. So the general counsel today is the owner of key decisions about legal work and has assumed greater significance within the corporate hierarchy as well. We're also seeing this in terms of with multinational companies setting up extended legal teams in India. So these are very much frontline, complex legal work that's being done here for clients across the world. And these teams are fairly large. For example, a US investment bank has a team of 150 lawyers in this extended legal team. Now, we may ask the question, okay, how does client principle apply to litigation? It may not be as visible in the dispute space, in the litigation space, but a few hallmarks that come to mind. One is we're seeing increased setting up of specialist disputes firms. We're seeing specialization in litigation, especially regulatory litigation as well, and the early formations of the bar in that regard. But I'd say it's the second principle, which is the technology principle that's having a greater impact. And I'll give you an example of that. Yesterday, Honorable Chief Justice mentioned increased digitization of courts, digitization of data as well. There is a legal tech startup called Legistify. They're a Y Combinator company. Their platform allows the corporate legal department of a company using the data that's there in cause lists across the country. I'm talking about tier 2 towns, smaller towns, to be able to make data-led decisions on which local lawyer to appoint for what case. Right? So we see the combination of the technology layer and the change in how the clients are also there, the client principle that's impacting litigation. And the last example I want to give here is on online dispute resolution. A lot happening there in terms of how technology platforms are being utilized to resolve disputes at scale, low-ticket, high-volume litigation at scale. So in conclusion, I just want to say that the client principle, India is becoming increasingly a much more important client driver. As we know, India is also a fantastic hub for legal talent, and together these principles will have a knock-on effect, and the future that legal education needs to really stand up to is to be able to provide, to enable this future that is right before us.
Thank you, Mr. Lukose. I'm sure that there's a lot of food for thought in it. The students sitting here might have noticed that there is a lot to study about the idea of client or the shifting meaning of the term client. And second one, you refer to this new styles and professional sensibilities. I personally believe that there are new professional sensibilities because the legal domain has lost its exclusivity, well, which could be for the good as well, that there are professionals from the frontier areas who have started to make a presence in the legal domain, contributing or fetching better outcomes. I'll now move on to Ms. Gulati. Well, you represent a regulatory body. You're an ex-academic. You are the right person probably to talk about my question number 4. Of course, you're also welcome to reflect broadly on the themes.
Well, when I saw the theme of the session, I was not really sure where I'll be fitting in, but after reading a little about it and after hearing all the distinguished panelists, I can say that I come from Competition Commission of India, which is purely a regulatory organization, but it is regulating an economic law. So when I speak from that perspective, I'm speaking more from the perspective of the economic laws and how they have evolved over time, and the role of legal education in furthering that particular evolution. So a lot has already been spoken about the global, the local, and the glocal. And I would say that when we say global and local, then obviously, when we talk about the economic laws, the economic theories are similar no matter which country you're sitting in. So the economic principles, the economic theories, and if we talk about even the conducts of players who are in the economic commercial space. So for example, if I talk about cartel conduct, I cannot imagine any jurisdiction which will accept cartel as an acceptable competitive practice, because there is a notion that when entities who are supposed to compete, when they collude, the consumers and the economy as a whole, it suffers. And that is one of the reasons that it tops the chart in almost every jurisdiction. Another thing is that with the rise of globalization and digitization in last few years, the actors, which are the subject matter of regulatory attention and regulatory scrutiny, are also transcending boundaries. So whether we talk about Google, Apple, Facebook, Meta, Amazon, their conduct is no more constricted to a particular nation. So when the firms are global, when the problems are global, we cannot have local solution to it. But having said that, where I see that, on one hand, there are obvious points of convergence. When we talk about, the laws and the conduct and the economic theories, there are also some points of divergence. So we are all, there are several countries, they are at different stages of their development. Their antitrust rules have been in place, when they were brought into place, that timing has been different. So for example, if we talk about US, the Sherman Act came in 1890, and our Competition Act came only in 2002, and it was operational only since last 13 years. Another thing is that our market structures are very different. So for example, even if we know that there are certain practices which will have some effect on competition, but depending upon what market power a particular player has in a market, that has to be seen in the local context. That cannot be bereft of the local realities. And again, whenever we are thinking of remedies as regulator, we have to be very, very cognizant about what remedies would work in that local context. So for example, if you have been following the latest data protection bill, there has been one of the things which is, considered as a safeguard. So if there is a lot of talk about the consent framework. So if a user is given notice about the purpose, extent, and scope of their data usage, and they give consent to it, it is considered that, that is kind of you're complying with that data protection bill. I'm sure, that is yet to become a law, and there will be consultative process around it. But we have to see that if an average consumer, maybe in the US or Europe, is less sophisticated, in India as compared to an average consumer in Europe or US, then maybe those kind of remedies, maybe that consent, maybe an informed consent when we talk about a consumer who's more sophisticated than a consumer who is localized. So we have to keep those market realities in mind when we are thinking of solutions that have to be local. And in that context, I think the role of non-state actors, the think tanks, international bodies, like ABA, OECD, International Competition Network, they play a very, very vital role in bridging this gap between the points of convergence and the point of divergence. And the two important functions which these non-state actors essentially do is, one, they act as a repository of knowledge of, what is actually happening in the local space. So by providing that platform for, having an effective communication, dialogue, exchange, and for stirring the kind of discourse that should happen in a country before anything comes there, they play a very, very vital role in that. Second important function which these think tanks and these policy institutions, or maybe even the academic institutions, do is that they act as taking the feed forward. So if something is being discussed in a local space and that is, or maybe applied in a local space and that has not really worked, so these think tanks can take that feedback as a feed forward for future solutions. And if I talk about, the role of the academic institutions, what I have seen in last many years is that economic regulation has been an area which has not been given that much prominence in the legal education, at least in India. Whereas there are laws where we talk about the laws, the situation in India, what is happening abroad. Like, for example, most of the law students would know the comparative constitution law, what is happening, how the American Constitution has come up and all those things. But when we talk about the economic regulations, maybe the competition law, the insurance law, the other laws, there is not so much knowledge about those laws. And if our future leaders are not equipped with the knowledge of, how those laws have to be shaped up and how the future policy discourse should shape up, then I see it as a serious problem from that point of view. And I think there the academic fraternity or the institution has a lot of role to play. With that, I would end, looking at the watch in front of me.
Thank you very much. I believe that one of the advantages of the regulatory bodies in this landscape is that they can regulate the local and protect it from the madness of the global. On the other side, the regulatory bodies, by creating a network of regulations, can facilitate the global getting assimilated into the local imagination. Now, one point you mentioned about the role of academic institutions, I feel that, I always feel that the academic institutions' primary role is that society has a quite fleeting memory, and phenomena are short-lived. So when a law professor or the students in the law school engage with that phenomena and wrap them up in the theories, they get a memory, they get a shelf life. So probably that the law school's role is actually to preserve these phenomena for the future generation. Anyway, now let me move on to Ms. Adonis. You are very advantageously placed. Being a member of the American Bar Association, you can actually reflect both on the legal profession and also on the legal education. Over to you.
Good afternoon, esteemed guests, international legal colleagues, and my fellow panelists. I am Maritza T. Adonis, citizen diplomat, global advocate, lawyer lobbyist, and chief executive officer of MTA Vision's global corporate social responsibility and government affairs firm in Washington, D.C. In this capacity, I provide advisory counsel to ESG, DEI, CSR. We also equip sovereign nations with strategies to advance the rule of law, diversify national security, and the use of arbitration and mediation, not only to resolve commercial and investment disputes, but also to resolve political disputes. We also partner with cities, trade associations, and universities to help them with their corporate social responsibility, international economic development, and public diplomacy programs, policies, and programs. I'm also here on behalf of the American Bar Association International Law Section, bringing U.S. greetings as the chair of our Young Lawyers Interest Network. I also would like to give a special greetings to my colleague, who is our vice chair of policy, Sylvia Kwe, who's a family and immigration law partner, who is essentially illustrating glocalization from a culture diplomacy perspective, because she traveled from USA, Kentucky, to explore synergies with all of you here today. I want to thank the organizers for their exceptional hospitality and for raising the bar for American Bar Association regional conferences. And so to my chair, Marcos Rios, I believe India may have beat Madrid. That's an internal ABA leadership discussion for later. As the distinguished moderator, Professor Sreejith, talked about, he outlined the premise of glocalization. He talked a little bit about the integration of the general human experience and how this transcends conventionally known experiences. Essentially, it's where the convergence of personal or social and our personal lives converge. It's where global meets local. Although the term global has been attributed to the Japanese idea of global localization, it was officially coined by Harvard sociologist Robert Robertson in the 1980s, which further popularized in the presentation of indigenous cultures and globalism. So given the sociological context of glocalization, why should there be an urgency to reimagine the local constructs of our legal education? The short answer is the private sector has beat us to it, as usual, vis-a-vis international trade and commerce. And one can also point to the public sectors when we look at the NGOs, such as United Nations and even from a diplomatic lens with the rise of BRICS and related. These, I should also mention, they should become as the experts that we lean to when we reimagine the future of legal education as it pertains to globalization. In January of this year, I had the experience of serving as a guest lecturer in the country of Colombia at their Universidad del Norte, where we talked about diversity in legal education, but from the lens of accelerating practice readiness and integrating cultural competency to the field of legal education. This session allotted the steps that we've already taken theoretically, but offered some room for improvements on how to integrate globalization of the legal profession through practice readiness. Yesterday, Chief Justice of India, Chief Justice Sreejith, exquisitely displayed how, although the penal code of 1860 is in effect, it did not limit his ability to modernize access and the delivery of fair and speedy justice for all through such innovations such as e-courts, translating judgments in native languages, and removing the economic barriers in judgments by making them free online. This is an exceptional case study for globalization in the legal profession, but from the aspect of the judiciary. So when the organizers yesterday planted a tree at the inaugural session to honor the momentous occasion, it brought me back to an experience where I had opportunity to plant the Soka tree in China, in Shenzhen, along my fellow Chinese and American government officials and diplomats, which essentially represented our US-China unity and renewed agreement to engage in fair trade. As India convenes the G20 summit, it is only right that I myself also exhibit my form of diplomacy today by planting a tree with all of you. I will do so by offering some seeds, albeit briefly, that we collectively as legal practitioners, members of parliament, and academia, together we can plant our tree towards globalizing the legal profession. A few of these are adapted from the CSR courses that I curated and taught at Johns Hopkins, and a few from continuing legal education presentations that I've made for corporate governance, rule of law with the American Bar Association. So seed one, politics. As lawyers, we have the tendency, and rightfully so, and as we are trained, to pursue justice within the confinements of the courtroom. As international legal practitioners, we know all too well that justice begins at the root of the human condition and isn't fulfilled until access is granted to all. But that is not limited to the laws of the land and the verdicts issued by a judge or a jury. I would like to challenge my colleagues today to fill in the gap in a key area that governs how we practice, politics. In almost all jurisdictions across the globe, Parliament writes the laws, executive agencies influenced by politics and the local customs and cultures, this is where the local meets the global, and the judiciary interprets the laws. With the centering of globalization, these institutions are going to lay down regulatory structures that our clients, if you're in-house counsel, would have to adhere to. We see this at play already in the United States Securities and Exchange Commission, SEC's proposed rules to enhance and standardize climate-related disclosures for investors, which is just one way that these politics and government agencies situate within the legal landscape. Albeit here in India, you're no stranger to the convergence of politics and agencies within, for example, the Companies Act, which under Section 135 provides for regulation of CSR and mandates that companies disclose, which is also regulated by your Ministry of Corporate Affairs. Another example and a comparative view of where government agencies situate within the legal landscape. Essentially, for my first seed politics, I want to leave us with the notion that we need more lawyer lobbyists, and glocalization is a great way to help legal practitioners find their standing in the intersection of law and politics. Glocalization will offer us the opportunity to get on the front end of justice before it is written. We're also most equipped, in my professional opinion, to forecast and resolve where the conflicts of glocalization will arise, and as such, should work in partnership whether it's as political liaisons, lobbyists, or as advisors at the nascent shapes of law writing. My final seed, education. The legal education has already been successful in integrating some aspect of globalization through transnational and comparative studies. As a result, it's not a matter of necessarily creating new legal curricula to situate globalization, but rather adding a chapter perhaps on cultural competency, intersections of politics, diplomacy, and the law, or as it pertains, public and private sector intersections as it pertains to the rule of law. This is just one piece, theoretical. The other essential piece, which my colleagues have stated, is practice. Practice before we enter the profession should be incubated via mandated legal clinics that would infuse globalization of the law as a tenet. This is where essentially our seasoned local actors, such as NGOs, think tanks, and consultants like myself, could assist with the reimagination of legal clinics to include, for example, rule of law clinics, international education clinics, and even diplomacy clinics. In conclusion, Glocal has already shifted the human, social, and legal relations, and social is becoming commercial. It is on this premise that my CSR and government affairs firm, MTA Visions, is prospering in Washington, D.C. and globally for such a time as this. So, as we see that Glocal has already changed the nature of disputes, we see a rise in selection of alternative dispute mechanisms as clients' first and only choice. We see innovative ways of dispute resolution settlements, such as green arbitrations and arbitrations in the metaverse. I'm more than happy to train your legal practitioners in the field of lobbying as my seed and planting of diplomacy, or curate courses on globalization for your law schools. And I look forward to the continued opportunities that the American Bar Association International Law Section will provide for us to continue watering our tree of globalizing the legal profession. With that, I am Maritza T. Adonis, Chief Executive Officer of MTA Visions, Global Corporate Social Responsibility and Government Affairs Firm, and Chair of the Young Lawyers Interest Network of the American Bar Association. With that, I yield to the moderator.
Thank you, Ms. Adonis. It has been very interesting. You pointed out vernacularization of social information, including judicial decisions as a classic example of glocalization or the local gaining prominence. And second one, there was an undertone of undertone of a clarion call, understand the agents of change and cling to them. That will make actually glocalization and the life afterwards much easier. I would like to spend a little bit more time with one final question. I request all the panelists to keep your response from 30 seconds to 1 minute. If I may take the liberty to submit this question first to Dr. Singhvi. I mean, of late we have been seeing a very interesting trend that we are getting too localized, that we are comfortable being in the local. There is a conscious effort to sever the local. I mean, we are seeing some efforts like Brexit, the Chinese exceptionalism, the rise of the BRICS. If this becomes the case, if this has not already been the case, how would legal education and legal profession respond to that? Or do you envisage an alternative future to globalization, legal education, and legal profession?
Well, obviously, if I could answer that in 30 seconds or 1 minute, I'd get the Nobel Prize for miniaturization. But I don't think there is an anti-global movement in some parts of the world. And two examples you gave. In some ways, you could look at it at Brexit or exceptionalism in countries. I think, fortunately, there is no anti-globalization movement inherently in things like legal education. I'm now being very narrow because of the shortness of the time available. So I think that's something to celebrate. On the contrary, there is a impulsion always towards welcoming new impulses which deal with globalization in this field. So I think that's something we have to be happy about it. Why should we think of nightmarish options which drive us in the opposite direction?
I concur with my fellow panelists. I think the legal education sector has done a great job of incorporating globalization within a context, whether it's international law or transnational education. But from the American Bar Association perspective, I think there's opportunities for our respective bar associations to connect specifically with our section of legal education as it pertains to reimagining what our curriculums will look like. This past year, our House of Delegates actually looked at the issue of removing the LSAT, which is one of the testing measures that's used to determine entry for law students to enter into law school, although it did not pass the House of Delegates. But issues like this are issues that we should be engaging, whether it's through education diplomacy efforts, so that we can exchange best practices as we move forward. But I think generally we're doing a pretty good job. And or if your young lawyers would like to join our Young Lawyer Interest Network of the American Bar International Law Section, we're actually working on removing some of those barriers as it pertains to the bar. And so we're trying to make it easier for LLM students and attorneys that are not barred in the United States to transfer their legal education and experience to the US. So there's lots of opportunities for us to continue to work on this, but I think especially from the American Bar Association context, finding creative opportunities to exchange best practices is the next way forward.
Thank you very much. I would take this opportunity to compliment American Bar Association here, because when in the context of legal education and legal profession, American Bar Association being very advantageously placed does a phenomenal job of what may be called expectations management, which actually could be the first step towards excellence in legal education, and definitely the ripples will be felt in the legal profession. Thank you very much to all the participants. Long live global, long live local.